So, Your Honor, before I turn to the specific evidence from the recent hearings that has been put together over the weekend, and the
can I just say this? Most of the recent hearings was taken up with your recusal application. So,
well, Your Honor, you'd be surprised.
I'm not sure that much more could be added.
You'd be surprised. I have some choice quotes.
I don't think I would.
But I just want to clarify one important matter, which I think will assist everybody in understanding the approach that I've taken in these proceedings. I am interested in demonstrating through these proceedings that a game theory model that I've been working on.
Sorry?
A game theory model.
That what? Game theory? That's economic, academic theory. Has nothing to do with this proceeding whatsoever.
Well, it does, Your Honor, and I'm explaining how. I've been developing a model that has to do with the distortion in the... If I may complete...
Sorry, can I just take you back, because I'm trying to take some notes, and I'm typing them because I forgot to bring my notepad, but you're interested in demonstrating through these proceedings that...
So I've been developing a game theory model, which I call the Folklore Effect.
The what?
Folklore Effect. Folklore. Folklore, space effect.
Folklore.
Folklore Effect, yes. And the emphasis in that model is on...
Oh, thanks. No, it's all right. I'll continue typing.
Is on the distortion of information by entities that have obligations to preserve its integrity.
That's all very interesting, Mr. Kuksal.
So, for a long time, I've been...
but it has nothing to do...
It has everything to do with this case, and I'm...
not interested in your...
Your Honor, this is a context...
So make your application, if you can, please.
I am making the application. I will demonstrate how it applies to this matter intimately.
Well, this proceeding is not about you trying to demonstrate some academic theory. That's not what this proceeding
exactly
is
what
for.
it's about, and I've been...
You might think it is, but it's not.
Well, Your Honor, let me explain how it's exactly relevant. And to clarify, for 3 years, I've been under constant surveillance, so I could record everything that I was doing, since before the start of these proceedings, because I was picking up fights with executive bodies, so I could demonstrate the effectiveness of the model. This proceeding was brought in as a reprisal to some of the things that I was doing against various people, and I have clearly documented how those things have been abused in these proceedings. I'll give you a context. So when the charges were brought against me, I was arrested, I was taken away, and I was prevented from actually enforcing my right to check whether or not a search warrant had been implemented. It is the duty of the police officers to show the residents whether or not there's a search warrant. I was prevented from calling a lawyer. Now, when I was in the cell at the time, and I was in tremendous pain from my gout attack at the time, but I created a scene at the station to make everybody uncomfortable and to have different people react to the fact that I was alleging that I was corruptly in jail, to get reactions from different people as part of the whole experiment, because what the experiment focuses on is how people distort information when they are either ashamed or traumatized. Because
trying to traumatize people.
Absolutely. The corrupt officials, absolutely. But it's a very specific kind of trauma in the sense that it only affects people who are doing
It's
the
not
wrong...
known that trauma affects people's the way people
Perception.
perceive things and
Absolutely.
and people's memories and
Absolutely.
reliability, but that has nothing whatsoever to do with. Well, you better get to the point.
Yep. So, Your Honour, I'll give you another example of how that's been used in these proceedings. On the
Kuksal,
No, Your Honour, it's important
this
because
is just, frankly, bizarre.
It's not, Your Honour, because-
and it is not assisting me at all. So,
Okay, Your Honour, if you could listen to me for 5 minutes, it'll give you some context. So on that day, there were police officers that stood up to Joel Carswell, who was the sergeant in charge, and then he had to go on and take several steps to suppress the evidence. That evidence was discovered in communication because of what I did that day. Then on the 3rd of May, after planning an exercise for several weeks, it was decided that I would place several police officers under citizen's arrest at the Werribee Police Station. And I had assembled around 8 or 10 people to go and effect that. At the last moment, Ms. Shu and Ms. Di Gregorio were directors of, or Ms. Di Gregorio was a director of the firm. Ms. Shu is still involved in a number of entities. They thought that it would be more confrontational if I was present, so they requested me not to come. And the idea was that we would play the audio recordings that we had collected and then seek to put some people under citizen's arrest because of how they react. On the day, incidentally, the officers that they found at the station were, well, the one officer that they found at the station from the time, Ms. Kai Wilkie Burke, was the one officer that we knew from the audio recording was uncomfortable with what was going on. So it was then decided that we wouldn't do that, but we would play the audio recordings and make a number of things known. Now, the idea behind that was to then generate a flurry of emails at their end, which we would subpoena later on. And we did. And that revealed a number of things about who in the prosecution was doing what Ms. Carol Orfanos' motive was. So throughout the course of these proceedings over the last 2 years, I have been initiating steps to know exactly what and when evidence I should expect. Now, I'm telling this now because they can't do anything. We've locked in all the data points and we know what to get. Now, with Ms. Naomi Burke, for instance, she read out her phone number in the audio recording. I know what her phone number is. I can subpoena her phone records, her personal phone records, which will show what her location was between 1:30 and 2:30. Every time someone receives a phone call, a text message, or even an update on their app, they connect to the nearest tower. Now, what we wanted to... On the 25th, I had only agreed to cross-examine Ms. McNamara because what I wanted to... And I will show you that in the transcript. But it was to get some precise information that I could use against Ms. Burke later on. And I got that information, which was when I wanted to narrow down the time for which I had to subpoena the phone records. I also knew that Ms. McNamara so I have profiles developed on each of these people based on everything that they've ever said.
Mr. Kuksal, you might want to just
No, Your Honour.
us about saying all this.
No, I have this. I'm publishing a book about this, which will come out very soon anyway. So this is, it doesn't, and it's relevant to this application, and I'll get to that now. It's relevant to this application because this is a case where you will not have a smoking gun. What you will have is discrete bits of incriminating documentary evidence that will need to be combined all together to paint a picture. Your Honour is fundamentally ill-suited for that purpose, based on how the proceedings have been conducted. For instance, Your Honour.
Well, you can't choose a judicial officer who is suited to your purposes.
No, but I have a right to enforce. I have a right to enforce my statutory. I have designed this. I was going to say game, but that not in the sense of trivializing it, in the academic sense of my defense, based on my knowledge of all the statutory provisions. And when Your Honour partially refuses to enforce some of them.
I haven't refused to enforce.
Well, a lot of them you have, respectfully, Your Honour. But let me just point one thing out. On the 25th of March...
I'll let you speak, Mr. Kuksal. I'm sorry for interrupting. You make whatever submission you want to make. I will rule on it.
Okay. On the 25th of March, this is the transcript that the court had provided to me, page 213. Mr. Prosecutor. And it seems to... Mr. Prosecutor. Prosecutor, sorry. It's not PRO, it's POR?
Yes.
Sorry.
What you do?
Sorry. And it seems to me...
What page?
Page 213.
On what date? Sorry?
25th of March.
25th of March?
Yes, 24.
Oh, okay, yeah, right. Sorry. Yeah.
And it seems to me that by agreement, we do agree that first of all, Your Honour needs to rule on the recusal application, but then we would be in a position to call 2 witnesses. This is right after the lunch break.
So what page did you say?
213.
Just a moment, I'll just get it.
Lines 17 to 26.
Hold on. 213.
Lines 17 to 26.
Moment. Sorry, I'm having trouble locating it.
May I just read them for the record quickly?
No, just wait. Yes. What?
And it seems, lines 17 to 26.
Yes.
And it seems to me that by agreement, we do agree that first of all, Your Honour needs to rule on the recusal application, but then we would be in a position to call 2 witnesses. I'll give an undertaking that if further information or evidence emerges, we'll recall those 2 witnesses for his benefit. This was an agreement that I had with Mr. Prosecutor during the lunch break, and I'll state for the record the specific terms of the agreement. What he had asked me was which witness, and the OPP instructor was present, and a number of other witnesses were present.
Yeah.
What he had said to me, he had first asked me which people I'd be interested in cross-examining.
Yeah.
I had made it very clear to him that my main motivation in cross-examining them was to get incriminating evidence so I could have them prosecuted. And based on that criteria, the only people I'd be interested in cross-examining at this stage would be McNamara and Stevens. And now I also want to cross-examine Bridget Thomas because of the new evidence that has emerged about the metadata, which emerged in December after Your Honour had finalized the list of people. Now, I take Your Honour to another page of the transcript. This is me. Now, I take Your Honour to another page of the transcript. This is me. Actually, can you send me that bit? I'm going to read I have the extract first, which I had put in a separate document.
Page is it from?
I'm being given the page number, but I'm just going to read the extract first.
Please give me the page number if you can.
I will, as soon as I get the page number from my associate, but I'm reading the part in the interim.
Just tell me.
Okay,
Just tell me the page number. Just ask your associate.
She's finding it, Your Honour, but may I not waste time in the interim and just...
Take your time.
Okay. No, not 28th, 25th. I'd sent this to you repeatedly. Just search for Thomas. Okay, so, Your Honor, this is page 268 on the 25th of March.
Right, just a moment. You find that. 268.
This is further particularization of the agreement before Your Honor. Okay? So, line 19.
Things changed, Mr. Kuksal, but
No, there was an agreement that was never changed. An agreement is a contract.
is it?
There was no subsequent contract between me and Mr. Posadu.
All right. Where will it take me to on page
So,
268?
line 19. So, what I've indicated to the prosecutor previously is that only two witnesses that are conceivably, three witnesses, that are conceivably not affected by the disclosure of those documents at this stage are Jeremy Stevens and McNamara.
Yeah.
And also, I note, it says no, but it should be note, I wish to examine the photographer, Bridget Thomas, because the metadata that has been produced is inconsistent with the affidavit of Bridget Thomas. She's the one with those two witnesses, okay? Now, let's go to the 28th of March, Your Honor.
I don't understand this. Just listen.
So, on the 28th of March, because now what had happened is Mr. Posadu realized that Your Honor was not really affording me the sort of procedural fairness that he would have otherwise expected.
Yes.
And that he was exploiting...
Take a seat, Mr. Kuksal. Mr. Perry wants to.
Respect, the accused can't possibly talk about what someone else realised.
I'm alleging. I'm not giving evidence.
No, I noted that. Unless he has been informed of that fact by the other party, or unless he's developed some form of clairvoyance, which...
Also, this is not evidence against him, by the way. This is a recusal application, and it's about how...
Where's your evidence about what Mr.
Trans-
Porter realised?
I'm getting to that, Your Honor. I'm getting to that.
Well, you just said he realised. Just take me to the evidence of that.
Okay, Your Honor, this is facetious. Okay, let's say I'm alleging...
Kuksal.
This is facetious.
Mr. Kuksal, I'm going to give you another warning. I consider that to be contemptuous.
Okay.
I'm not going to do anything about it at this stage, but I'm making a note of each of these contemptuous remarks that you
so am
make.
I.
And I will reserve the right of the...
You can't actually do that.
I will...
You can't by law. You can't do that. You can't...
Mr. Kuksal, I am making a note of these contemptuous remarks that you're continuously making, notwithstanding my warnings, and I'm reserving the right of the court to take action in relation to that. So
You can't actually do that because that's... No, this court can only charge me for contempt in the face of the proceedings.
Well, I consider that was contempt in the face of the
Yeah, but you have to do it at the time. You can't do it...
I said I'm not.
Okay, well then you can't use it later because this is done in the heat of the moment. It's done based on the expressions of Your Honor, what Your Honor is saying. It would be extremely...
What expression did I
Let me
give
get
you
this
then?
on the record. Don't...
Mr. Kuksal, what expression did I give you then that caused you to say that what I said was facetious?
It was the promptness with which, and the smirk on Your Honor's face, and the relief that Your Honor experienced when Mr. Perry took the objection. Your Honor was waiting for something, in my view, based on... Your Honor, this is what I do full time. I analyze body language. I'm writing about it. That's all that I've done in these proceedings, and that's how I've gained a lot of evidence against different people. That's how I got Ms. McNamara to bring up the statement the following day, despite the efforts that Your Honor did to
I
impeach.
reject your assertion.
Okay, I have
that
transcript
smirked
excerpts.
at you.
I have transcript
I
excerpts.
reject your assertion that I did anything to cause you to describe what I said as facetious. I reiterate what I said earlier, that I consider it contemptuous.
This is recorded. I can subpoena the recording.
Yes, you can.
Yeah. So what I'm saying is that, Your Honor, that is not the point whether or not...
So when you just said then this is recorded, you pointed up to...
The camera is recording you. I'm just pointing out to the screen that shows you...
No camera recording me, Mr. Kuksal.
Your Honor, I've previously subpoenaed camera recordings from courtrooms, from this court.
Recording me.
Are you saying that the camera that is displaying you on the screen is not recording you?
Not recording me.
Okay, I've previously... The court will... I can provide that right now.
Oh,
It is
Can you
recorded.
take that off?
Sorry, why are you taking it off? You just asked her to take yourself off the camera.
Yes,
This is.
I did.
So after I told you that I'm collecting evidence of your expressions,
I-
you just asked.
Normally, and I'm not recorded. That's not the normal process.
It is always the process. I know the process. I've subpoenaed the recordings of magistrates before.
It's not.
Can I play them now to show you? I have them on
Not
me.
interested in that. Please
Okay,
don't
so
do
you
that.
just asked her for the record to take you off camera after I told you that the camera recording.
I would normally, if I'm aware that I'm on camera, I always ask to be taken off camera in court.
Your Honor, you threatened to charge me with in my view, Your Honor was complicit.
Kuksal,
No, you need to let me.
I considered you saying several remarks you've said today.
And I said your expressions would
Kuksal, please
corroborate
don't
my.
interrupt. I consider your several things you've said today which impugn the propriety of me, that describe my remarks in court as facetious. I consider those matters to be contemptuous. I'm not doing anything about it now. I will let it go, but please be aware I'm making a note of these remarks, and you need to be aware that if you continue to engage in this behaviour, there will be consequences.
Yeah, and not after you destroy the evidence, though. Don't be on camera, please, and then you can charge me. I would really.
Mr. Kuksal, these proceedings are recorded, as you well know.
But you just asked her to take you off camera.
Yes.
That's wrong. I'm alleging that your expressions reveal.
I disagree.
How can you disagree?
I just did.
That's fine, but you can't destroy the evidence of it at the same time. A third person should be able to assess whether I was right or you were right. You know that the Judicial Commission of Victoria is investigating these complaints as
Only
we
because
speak.
you told me. Normally, of course, if there's a complaint made to the Judicial Commission where there's an ongoing proceeding, the judicial officer is not notified. The only circumstances in which that would occur is, as occur here, you told me.
Yeah, and now you're
That is
destroying the evidence.
You've lived with the consequences.
And you're destroying the evidence that the Commission could have gotten.
What should I infer from the fact that you told me about that complaint?
I had to tell you because you were impeding the process of getting the audio recordings. They asked me for the audio recordings. I had to tell the court because I have to state the reasons. Also, on the audio recording, it is a condition that I set out every purpose for which the audio recording will be used. I had to take explicit permission from this court, including Your Honor, where Your Honor is releasing the audio recordings, that I should be allowed to use them.
Continue to tell me about your game theory modelling, Mr. Kuksal, but and I will not interrupt you, providing you do not continue with your contemptuous remarks. Do you understand?
I wasn't even directly criticizing Your Honor. I was talking about Mr. Porsadou, against whom I'm not giving evidence. I was simply pointing out the context. Anyway, what I'm saying is Mr. Porsadou clearly, the evidence would indicate, circumstantial evidence I should say, sought to exploit an opportunity that was created. And this is what Mr. Porsadou. So, firstly, Mr. Porsadou sought to deny the agreement had existed. Then I said it's documented.
Where are you talking about?
I'm not referring to every line because we'll be here forever. The transcripts
Take as
will
long
be.
as you need.
Okay. Okay, let me first take Your Honor to page 565. No, this is not the one.
Well, no. The accused is checking, Your Honour. I just wonder, for the sake of clarity, and it's not in any way done intrusively, I'm quite content to resume my position at the bar table.
No.
Whether what he's the stumbling block might be informal discussions as to who you wanted called, and then a final communication to him that X, Y, and Z were available, in fact, to be called.
No, that's not what I'm saying, and you weren't there. So please...
Please don't interrupt me. I'm sure it's just unaccustomed rudeness on your part.
No, only when people are acting in a corrupt way.
Well, all I need to know, Your Honour, is whether the accused has some mistaken belief, which can be clarified.
No mistaken
If
belief.
he says there is no mistaken belief, then I invite him to point to specifics of evidence. In my submission, it isn't corrupt, but it is fast becoming necessary.
Okay, so Your Honour, to clarify...
I agree.
I know you agree, but just pause a little bit. It makes it look like you thought about it first.
Mr. Kuksal,
Yes.
I warn you again. That was extremely improper. It was clearly contemptuous, and
It was not contemptuous. Every criticism is not contempt.
Mr. To say to a judicial officer, just pause a little bit, it makes it look like you've thought about it first. You saying that is not contemptuous.
It's not contemptuous of the
I'm leaving
court.
the bench, and I'm going to go consider a position on this one.